I guess we can start with the pledge. Eric, will you?
Pledge allegiance
To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, liberty, and justice for all.
Harold's gonna dart in and dart back out, so, I'll wait on the Hitchcock thing until he gets here. I'll open it up to public comment, if there's any public comment about. Well, if there is any.
Actually, I have a quick question. When town bridges are posted for a certain tonnage, and they're a low tonnage, how do vehicles legally cross over them?
They can if they're above the tonnage.
That issue was raised at the planning board. I mean, they still have to be able to get over. Garbage trucks are 60,000 pounds. So it doesn't matter what the bridge is rated for. Is there like a policy on that? Or is it just like a heavy traffic?
We don't regulate that, do we?
But the fire department was asking about private bridges and how if there was a way that the town could kind of force a 20-year inspection or some sort of thing like that. And I was just wondering, there's a lot of posted bridges that are 8 tons. The fire trucks are,
Our bridges are inspected regularly.
so it's 8 tons, like the fire trucks are way over that. So how do they cross? I was just curious.
You know, if I can,
Yep, please.
I've not done that issue with bridges, but I'll give you this example. Town roads, weight
Yeah.
limited, those are enforceable except for emergency purposes and local delivery. You have to be able to get trucks in.
So I guess, so for local delivery.
Yeah.
And fuel trucks, they weigh way over what it's posted for. So bridge.
That's
is
the
there-
issue.
I
There's a
guess-
safety issue there with the bridge.
And
It's
that was,
different with a road.
that was kind of where I was going. Is there a safety factor written into it? Like, it's built to handle it, but for daily heavy use, it's only rated for this?
That's a fair question. I don't
I was
know the
curious.
answer to that yet.
Who would be,
I'll ask DJ, he'll find out first.
should have started there.
I was informed that they're no longer gonna, carry our current radio transmissions, and that we need to do something different. Early estimates are $29,000 to get into the new system. DJ's looking into several different companies right now, or with Wells, but there's a company in Auburn that does it. It's cheaper. It's just a matter of finding who has the space in the towers that will cover our area and who can do it. So it's gonna cost us, I don't know how much it's gonna cost us, but if the early estimates are 29, maybe we can get whittled down, but that's a lot of money.
Is there any reason why they can't just use their cell phones?
I don't know.
I mean, cell coverage is rough.
Yeah, during the storms and stuff, up on the mountain.
There's more dead zones popping up, or like low coverage spots where it shouldn't be. And I don't
What
know
about-
if it's,
I don't know who does what system the emergency dispatchers are on, but this coverage is phenomenal. I don't care if you're ever.
that is true. The emergency coverage is different than the little peon.
The radios that the school has, you get them tapered in, East Post Kill.
I was talking about cell phone usage.
No, this is, the,
Radios are different.
in their trucks.
What about higher powered radios that like consumers can buy?
I know, you'll have to talk to DJ, he's gonna.
Some of those can go
he's
five-
gonna
five,
have put a
10
report
miles.
together for us, but he could
These
call
are
me.
the ones that are in the truck, so they're not always gonna be in a 5 to 10 mile radius.
And they have to change. Be flexible.
They're
I
totally,
don't see spending $29,000 for that.
it's totally dependent on the Wi-Fi connection.
Right, but the radios that used to be popular at ski resorts with families, those are only go maybe like a half a mile to a mile, but then they have more powerful ones that don't need a central system. They do radio to radio if you're on the same frequency. Might be worth looking at as an option. Maybe it's not practical, but
Well, we're not the only ones in this group. Well, Sand Lake, Brunswick, everybody that's using their current
who's the company?
Motorola. Okay, I
Motorola.
promise Farrell will
Alright.
get in now. We've all had our packets. We all know what's on the table. We have a settlement agreement proposed. Basically, I'll entertain a motion to accept the proposal. Do I have a second?
I'll second it.
Sue, can you do an or
Can we have a discussion on this before you vote?
well, we beat it to death. I told Harold we get him out of here, but go ahead.
Well, I think it's important to discuss how we got here, because, you know, this all started because of a noise complaint. And it started because a neighbor was doing a use that was not allowed in the zoning, and that's where we all got started from. And we made a lot of mistakes in this case, a lot of mistakes. That doesn't mean we have to keep making mistakes. We all make mistakes. But what you have to do is learn from your mistakes and not repeat the mistakes over and over again. You know, this all started, you know, I just want to talk about a few things that Mr.
All right.
Hitchcock.
Wait,
Excuse me. I got it. I said I'd stay.
okay, you know what, I'm gonna call for a vote.
Wait a second, I have the floor. I
Okay,
have the-
Harold is sick, and you know what, you can
Well-
discuss it till you're blue in the face. I'm going to move this.
No, I still have the
Okay.
floor, and I want to talk about the fact.
Sorry,
that
Harold, if you dropped the die, and I can't do anything about it.
This is how government works.
We
It's a
have,
discussion item.
I'm sick. I'm really sick.
Yeah, I know. Can we, he can come back and,
no,
doesn't
we can't.
mean, oh, then,
I was here.
I'm not trying to be disrespectful to Harold. I have a right to say what I want to say, and that's
I think
that.
you've been disrespectful. to everybody.
Absolutely not being
We
disrespectful.
beat this to death. till blue
We
in the
haven't
face.
beaten this.
You know,
death.
we would have the
have
same
not beaten this
conversation.
and that
We all know
in
how
a
we got here.
situation
Because it started before
when
I
we
got
have a
here.
public, this is a public
All right,
matter.
Harold, just do your
I'm
thing.
not interrupting you. This is a time for discussion.
Then do it.
We're in an open discussion. We've had discussions in executive sessions, not in open public. That's what I'm here for. I'm
Okay.
sorry that Harold said.
I know I don't have the floor, but you just drove an older man out of
Look
the.
at, let it go.
Is he
Let it
sick?
Hold on a second.
Really
This
hear
is
it
the
before.
first time.
Stop. That
This
doesn't
is
help.
the first time we have had opportunity to
Hey, Will.
discuss this in an open session. First time.
I really
Right?
don't care. What you
First
just did,
time?
Harold,
I'm
All
not
right,
writing
Steve,
anything.
look at, this isn't a debate. Just go ahead.
You want me to continue?
have at it.
Yes, please continue. Let's finish this up.
It'd be nice if I wasn't interrupted, but let me start again. This started based on the Hitchcock's own legal documents, that he bought the property back in 2008. And says here in their documents that shortly after purchasing, Hitchcock successfully obtained a building permit for the town for a storage building to house his wood processing. It also states that he cut and sold wood during the weekday afternoons, about 3 p.m. to 6 p.m., and only on Saturday mornings. And our first complaint came in 2019, and in November of 2019, our former code enforcement officer issued a cease and desist order. A cease and desist order that wasn't abided by. And later in November of 2019, the former code enforcement officer visited Mr. Hitchcock at his residence, not his residence, at the location, and handed him a cease and desist order, of which he did not abide by. At no time, based on the information we provided in our response to the lawsuit, did he ever stop his business up there. In March of 2020, a member of the planning board went up and visited Mr. Hitchcock and told him that at that point, he should be applying, he should apply for a permit to continue to do his business. In April of 2020, the code enforcement officer, a new code enforcement officer, issued another cease and desist order, which also was ignored. In our own lawyer's document into this case, we stated that Mr. Hitchcock was harassing and intimidating his neighbors. So from April of 2020, we then go to the summer and fall of 2020, the zoning board, which ruled that it was not a retail business. And then in December of 2020, Mr. Hitchcock filed an Article 78. And then we fast forward to April of 2021, when this town board passed quickly a the law that we're now discussing. And the reality is, you know, we have to remember that the neighbors had an understanding of what the zoning was allowed in that section. And at the time, what he was doing was not allowed. And what this town board did was not that we just say, we understand that we have a history of people chopping wood and selling it to their neighbors, which is perfectly reasonable. But we passed a law that allowed him to do commercial wood processing. And that was the difference. And I voted against that bill, and it passed 4-1. And I sat here and I said, and it's based on the documents that the lawyers presented, that we were in the midst of this Article 78, and we passed a law, and we hoped that we were done with this problem. And it was the wrong thing to do. And then we move on to the fact that we have a lawsuit filed. And after the law was passed, we issued another cease and desist order to Mr. Hitchcock, when he didn't abide by that one either. And in his own documents, his lawyers say prior to the passing of the law, Hitchcock was never charged with violating a cease and desist order issued by the town. Prior to the passage of the law, no hearing was ever held to determine if Mr. Hitchcock had violated the cease and desist order issued by the town. And prior to the passage of the law, no court ever found that Mr. Hitchcock had violated the cease and desist order issued by the town. So we have issued 3 cease and desist orders from 2019 to 2020, and then in 2021, of which we never enforced. And that's part of the reason why we're here today as well. In May of 2021, Mr. Hitchcock is ordered to go to court based on the 3rd cease and desist order that we give him. And it states here that the defendant could not be fully arraigned at the time because the town attorney had not yet filed the court accusatory instrument. The return date after May 19th was May 24th for further discussion amongst Mr. Hitchcock's attorney and the town. The defense counsel and the town attorney at that time discussed the case, and Mr. Hitchcock at that point decided to cease and desist until the next town court appearance, which was set for June 14th. Okay, so those dates are important because later on, based on the information they provided, it says, however, to keep his business going, on or about June 4th, 2021, Hitchcock agreed with neighbors to start harvesting lumber at their location, which we know about. Now, why that's important is because for the first time that they're admitting to the cease and desist order is May 24th, 2021. And then within 10 days, they also admit that they start an agreement with neighbors and start harvesting wood again. It's important because we're about to vote on a settlement that has no damages, because there was no damages because they never stopped his business. By their own admissions, he may have stopped his business for 10 days between May 24th and June 4th. And that's what his own attorneys mentioned in their filings. You know, from that point, we get the lawsuit, which is why we're here tonight. And it's important to note that the lawyers for Mr. Hitchcock foiled our town records, including our own emails and the things we said here at the town board meeting, and used our own words against us. And in the judge's findings, it's also important to note that our former town attorney, not Andy, actually had to be recused in this case because he became a witness in it based on some of the emails that were back and forth. And in the judge's finding that didn't go well for us, he states that a council member's statement in an email that, quote, there are those who think it is only fair to grandfather in zoning district RR1 as well. If not, we exclude significant part of East Poston Kill. Think Tom Homan. However, quote unquote, the fly in the ointment is the fact that the plaintiff is in RR1. The judge went on to say that by considering plaintiff to be a quote unquote fly in the ointment, the town board presumably meant it did not want the plaintiff to operate his wood processing business, whereas others wood processors, such as Mr. Holman, were allowed to continue their business. And in another record from our own town board meeting, another person on the town board said, quote, make another lawsuit, file another lawsuit, do it forever, I don't care, it's not my money. Then we get to the agreement, and I have a problem with the agreement because we don't get a sentence in and there's already a problem with the agreement. It states here that this settlement and agreement as of this date is made between the Joseph Hitchcock residing at 160 Lynn Road in Postonville. We all know that he doesn't live at 160. He even said so in his own court. Why would we want to sign something that we know is absolutely not true? I don't know what the benefit is to him saying that he lives at 160. We all know he doesn't live at 160. He doesn't have a building permit to live at 160. He doesn't have septic at 160. I don't understand, number one, why that would even be under consideration. In this agreement, it says all wood processing operations of plaintiff and the property include the operation of firewood processor, the delivery of logs to the property, and to the offloading of said logs from flatbed trucks onto the property, but excluding those wood processing activities set forth in paragraph 7 below, shall be limited to the following hours of operation of 7 a.m. to 6 p.m. Monday through Friday, and Saturdays 7 a.m.
We haven't voted on this yet. And
It's being publicly discussed.
And then it goes on to lay out what wood processing is. I won't get bored into the details of what we think wood processing is what we think it is. But then in section 7, it says, all other activities by the plaintiff at the property, including to but not limited to the relocation of firewood and materials from one end of the property to the other, stacking of previously cut firewood, grading and cleanup activities, and sales and delivery of firewood to others may continue regardless of the hours, and subject to the neutral enforcement of the same general zoning and land use applicable to all property owners. And then goes on to say, subject of the provision that the loading of the firewood onto trucks or containers for sale via the use of a Cat 906M compact wheel loader or a substantially similar loader shall not occur before 7 a.m. or 7 a.m. or after 8 p.m. on any given day. That goes against our own town laws and codes where work has to be done at 8 o'clock, at 7 o'clock.
No.
And it also says on any given day. That is, again, not something we should be agreeing to. We're now letting him do more than what we allow for the rest of the town. Then it goes on in 8 to say the limitation of the use of a loader for loading the firewood into containers and trucks for sale is set forth in paragraph 7, shall not be interpreted as restricting the plaintiff from using a loader for any other use, and is expressly acknowledged that such loader may be used by plaintiff for the purposes of snow removal, soil handling, relocation of firewood and materials from one end of the property to the other, stacking of previously cut firewood, as well as general maintenance, grading, and cleanup of the plaintiff's property, again, regardless of the hours. Then goes on to lay out the amount of equipment he can have on his property, which is 1 wood harvester, 2 skidders, 1 rubber tire loader or compact wheel loader, 1 tractor, 1 skid steer, 2 dump trucks, firewood processor, a dry kiln, 2 log forwarders, 1 wood chipper, a bulldozer, a knuckle boom. The containers and the trucks brought to the property by others and the firewood loading containers and the trucks, brought to the property by others for firewood loading quantities will vary by day. As the equipment and machinery are replaced in the future, The replacements shall be subsequently similar to the equipment and machinery stated in the list above, provided, however, that nothing in this agreement shall be interpreted as preventing the plaintiff from acquiring more environmentally protective or innovative machinery and or equipment to replace those currently in use. So even though we lay out how much he can have, it states here, he can have more. We can't hold him that if he wants to add to that. And then finally, the worst part of this agreement, if the other ones, in my opinion, are, what if there is noise complaints in the future, even if it's after, we're basically giving him the opportunity to work whenever he wants to, as long as he says it's for snow removal, soil handling, relocating of firewoods or materials on the property. At any time, if he decides that he's doing those things, again, regardless of the hours, he can do that, which is something we don't allow to anybody else in this town. But if there were someone who were to make a credible complaint about the plaintiff, it's stated here that upon a credible and verified complaint that the plaintiff has engaged in wood processing on the property in violation of an agreed upon above the hours of operation, which again are regardless of the hours on any given day, the town of Poston Hill shall have the option to enforce this portion of the agreement as follows. One, to ensure the confidence in the process, any such complaint must be written and sworn under oath and subject to the penalties of perjury. I would like to know how we would do that. What the process we would do to take a complaint and make sure that we are swearing it under oath as a town. Then it says the plaintiff shall be served personally or by certified mail, return receipt required to an address specified by the plaintiff with a written notice of violation, and to be provided a copy of the written complaint and the supporting document or evidence that forms the basis of the alleged violation. Then it goes on to say, within 10 business days after service of the written notice of violation, plaintiff or counsel shall contact the town code enforcement officer to schedule a meeting to discuss the written violation, which meeting shall take place within 10 days thereafter at the plaintiff, and on and on and on. And a violation of $400 shall occur within the first 180 days of the previous violation agreed upon by the plaintiff, result in the payment to the town of Poston Hill of $800 violation within 1 year of the two previous violations shall be result in the payment of the town of Poston Hill is $1,200. And then it goes on to say that should the plaintiff contest the allegations that are made against them, after someone makes an allegation, after we swear them in on perjury, on a subject of perjury, if he chooses to disagree with what we have said, the town may enforce the terms of the provisions of the agreement in a civil action in any applicable court in the state of New York against the plaintiff. In any such civil action in the courts of the state of New York, all conveyance of confidentiality contained in the agreement shall be waived, and the evidence shall be received and weighed in accordance with the provisions of the acceptable law. There's nothing in here that states criminal action. So basically, if he were to not abide by the agreement, which we're voting on, he would then, our only course is to take him to civil court. This is a bad agreement. It's making a mistake on top of a mistake. Again, we're allowing him to work up until 8 o'clock when the rest of the town can only work up till 7 o'clock. He's now getting more than other folks get. It's in there several times that regardless of hours, as long as he determines that some of his work is the things that we've laid out in there on any given day, and that there's nothing here that prevents plaintiff from acquiring more machinery or equipment in the future. And again, with a civil action and no criminal action. And the worst part of all this is the fact of the matter is, how did this all start? This all started with a noise complaint. And the reason why we need to have a noise ordinance policy in this town is so that we protect the person who makes the complaint, we protect the person who's being complained about, so that we can protect the code enforcement officer, and so that we can protect the town board. If we had a noise ordinance policy in place 3 years ago, we wouldn't be here today. We'd be able to say, no, this is the process we take. We get a complaint, we follow this, we methodically go through it. You weren't being singled out. And that's why we need to have a noise ordinance policy in this town. And I hope that someone, and one of my colleagues will work with me on that, because it's exactly the same mistake we're making again with currently that we made 3 years ago. And I don't know if we're gonna be able to vote tonight, but I think ultimately, we have to be careful how we vote, because I don't know that we're gonna be done with this if we simply just pass it and think we're done with it, like we thought we were done with it back in 2021.
Since Keith called this special meeting with the understanding that you had a meeting in Brunswick at 7, I would make a motion that we.
Well, wait, hold on. Is there any way Harold can vote by phone or?
No.
I just want to remind you that there is a motion on the table, so
But I would just make a motion that we reschedule this meeting so there could be an open discussion if anybody else wanted to speak.
I would call another special meeting, but I think it would probably have the same rules. If you're against it and you want to find a way to stop it, then you always will. And that's what happened tonight. You cherry picked and you made claims that aren't accurate. I can't stop you from doing that at our next meeting, so take a vote. When this ends up going to court, the same judge that just found us guilty decides again, just remember, Tracy's bills won't be paid for. We're gonna pay for them, or Tracy's gonna pay for them. The bills for litigating this is gonna be ours. And if by chance this judge holds a grudge against us for not abiding by his agreement and finds in the plaintiffs, we're on the hook for whatever he charges, 230, $1 million, the town will be on the hook. Right now, we walk away with no debt. And you're right, this isn't a perfect agreement, it stinks. I sat in court for a whole day, making many of the same arguments you made. The judge doesn't want to hear it. To protect this town, you should support this and swallow your pride and know that you're protecting town. Are the residents going to be happy? No. They're probably going to litigate this and they probably have some claims. But in the meantime, you got to protect the town. And this judge has made it very clear that he's fighting with the plaintiff, not us. And if you want to roll the dice and say, hey, you know what, we'll take a chance, it's on you. But this is a stupid move, in my opinion. You're risking an awful lot for your pride.
I don't think that's a fair
Can I have a
assessment.
comment? I substantially agree with everything Eric said. But I think one of the interesting things that he brought up was the fact that his address is wrong. There is not a house at that address, so he can't live there. So at the very bare minimum, this should be edited to get his correct home address, because this is just factually wrong. I think that's at a bare minimum what should be done before we vote on this.
What's the ramifications if we don't vote?
I don't know in terms of the court procedure. Certainly the judge was looking for a report after your regular meeting last week. We informed your insurance defense counsel of the situation with one member being ill and not able to attend, that a special meeting would be held. He alerted the court. Court is aware that there's a special meeting tonight. I would presume is expecting a report tomorrow. I don't know what the court's reaction will be. It could be, okay, let us know when the next meeting is. It could be something different, that I don't know. And I've not talked to the town's defense counsel on that issue. Certainly he was expecting a vote tonight as well. I can tell you again, like last week, that you do need the affirmative vote of 3 members in order to approve the agreement. And a 2-2 vote can be deemed to be non-action. There is some arguments that it can constitute a denial, but there's some cases that call it non-action. I certainly never recommend to boards that are sitting where there's an even number of members and anticipating a tie vote to move forward, but that's always within the board's discretion.
We have a motion, I have a second, we really don't have a choice.
No, it can be withdrawn
It can be withdrawn. It can be procedurally
and then
withdrawn.
brought up at the next meeting.
But that's within the board's discretion.
Well, if Dave says it's a good point about correcting the address, so we can withdraw all of that and then have a special meeting.
Or have it at our next board meeting.
Next meeting.
I don't know we have that much time.
Right, I will caution that I do think the board.
This judge has had it, he's done.
The
He's not
board's
finding in our favor.
schedule has to
Well,
be-
I think this talking about a judge who's obviously so prejudiced against the town that there's obviously,
I will cut you off on that, on the public record. Certainly, the court is sitting as the arbiter of the plaintiff's claims. Many times, a judge will agree with one party and an adverse decision to the other. That's not an indication that a judge is biased.
okay,
It's simply, you may have a different opinion as to what the result should be, what the law should be. In the opinion of the court, the decision they rendered was in compliance with law.
okay.
So what happens if Harold is still like the sixth, even if we did it like next week, then there's no saying that he's gonna be able to vote.
Correct.
So
Correct.
then-
I'll go over this issue with the board as well. State of New York has allowed meetings to be conducted remotely, but in order to do that, you do need to adopt a local law allowing that in compliance with state law and establish a fairly detailed policy regarding how that occurs so that the public is on notice, so that it's in compliance with the open meetings law. Transcripts will need to be prepared when there's a virtual meeting. As opposed to just minutes, so we'll require transcripts be prepared. So there is that option. That will take a period of time to go through that process if the board wanted to. That certainly would take months, not by your next regular meeting. So unfortunately, right now, the open meetings law does require the members to be in person at an open meeting available to the public like to see.
So in your opinion, is it better to at least vote tonight to say that we have tried to move forward in an attempt to?
Well, I'll advise you that as I sit here right now, I don't know what the result would be if there is a 2-2 vote, whether the court would ultimately deem that to be non-action and you've got to basically review it again. I've dealt with that issue in the context of a planning board and a zoning board. Those procedures are a bit different. This is a town board, so it's a legislative determination. You have basically different discretion on that. And I need to look at what the legal consequence of a 2-2 vote. Certainly it would not approve the agreement, whether it's in fact a legal disapproval, so that you couldn't consider it again, but that I don't know, or whether it would be deemed non-action. These are the unfortunate legal issues that come up when there's
There's a possibility that if there's a 2-2 vote, it cannot be brought up again.
It's possible that you've already acted on the agreement as proposed, and if the legal result of a tie vote is it's not approved, I don't know that this could come back to you in the same form.
So perhaps it'd be better to wait till the town board meeting.
I didn't make the motion, so if somebody wants to withdraw a motion, I'd be more than happy to entertain that.
It's interesting, I do believe, Jim, you did offer the resolution. If memory serves me right, I think Harold seconded it, and he's absent. You can certainly withdraw your motion, or withdraw your offer of the resolution, but oddly enough, Harold was the one who seconded that.
Are you gonna withdraw?
I didn't say that this meeting, if you want to do it too.
Yes, I'd like that, because I'm telling you that if we go forward, it's rolling the dice, you know, you're got the same judge. And right now, they've agreed to pay for all Tracy's expenses. They've agreed to pay for all litigation up to this point. He can't work past 8. What the judge said when I brought up the whole thing, well, we want him to stop at 6. He said, well, actually, your town law says he can work till 10. He's compromising, you're not. So you're claiming that we're stopping other people. No, our noise ordinance says 10 o'clock. It doesn't say 7 o'clock, it says 10. And as far as the equipment, You're never gonna tell people they can't buy a new skid steer or a new tractor when their old one breaks. It doesn't say that he can increase the capacity of his operation. It doesn't say that anywhere.
It says that it cannot without a special use.
That's what it says. That's what it says. Well, you're not an attorney, and that's what, I take the advice of an attorney.
We also took, it's fine. That be said, for the record, I didn't know until you said Harold, I didn't know Harold had to be here for 30 seconds, that was it. So that was not the intention of this. I have a right to my opinion and to state the things that I want to state.
And
I didn't know,
and I would've given you
I'm
all
still
night long
talking
to
to
do
you.
it.
I'm still talking.
You're always
I'm
always
still
still
talking.
talking. I'm
Don't
still
interrupt
talking.
me.
All right,
I
I am
don't
gonna
interrupt
stop you.
you.
I'm going to stop
I
you.
don't
We're
interrupt
not
you.
doing this. You
I
can't
asked
interrupt
you
me.
not to interrupt me.
I was talking, you interrupted me.
Okay, then finish.
So,
I'm just saying that I didn't know Harold had to rush out here in 30 seconds. So it was not my intention to stop a vote tonight. I have an opinion on this. It's the first time it's on the record, and that's it. I didn't know Harold had to rush out of here, but I'm sorry that that's the way it happened. I expected to vote tonight anyways, but I was gonna have my piece. That's all.
It has been discussed in great length. We've
It's
had
not been
public
discussed.
hearings. I've been at public hearings where people were screaming at each other. We had to have police at them. If you're saying this hasn't been discussed in public before, you're mistaken because you just didn't attend those meetings.
okay, so let's resolve everything. Do I withdraw my, okay, I'm withdrawing my motion for the special meeting and then it just goes to the town board.
Right, if your intent is then to withdraw your offer of the resolution to approve the agreement, and then also to table the discussion to a further special meeting. Special meeting or next regular town board meeting, that's up to the town board. What you do is we withdraw your offer of the resolution, so it's not.
I think consider Harold's health situation, waiting 2 weeks would be prudent.
We'll just move it to the
Town board meeting.
That's more than 2 weeks.
Right, that's,
Almost a month. And the judge isn't gonna have that. I think you schedule another special meeting because he is not gonna wait another month. And I'll tell you what, if we don't do something shortly, he's gonna impose something on you much worse than what you're looking at now.
So we'll adjourn this meeting and speak with Harold about what he feels capable of doing perhaps next week or.
Well, I'd like to schedule it and talk to Harold about if he can make it or not. I don't think we can just schedule a meeting over the phone.
generally the supervisor calls the special meeting. Many times it's done during the course of this meeting. It'd be prudent to schedule it. It can always be, if need be, the call of the supervisor. If that special meeting date has to be changed, that can be done. We'll go over the timeframes with you.
Well, I'd like to schedule it for the 22nd and hope that he's healthy enough to make it.
1 week from today.
Yes, same time, same place. Yeah.
Okay.
All right, I'll call the meeting to adjourn. Wait, we do have an executive session over a personnel issue.
Keith, I hate to do this, but the special meeting notice for tonight was limited to
All right.
the Hitchcock matter. I certainly want what you're
Okay,
about to
then
talk
I
about.
want to adjourn the meeting. Sorry to drag everybody out here tonight. There we go.
Do you have a motion to adjourn?
I'll make the motion.
I'll second. All in favor? There, you go, set.
You have to drive fast.
No worries. Okay.
Simple about the-
No.